All right, it's 9 o'clock. Chair, if you want to gavel us in, we can get after it.
Very well. It is time. We will start the meeting. This meeting that, as of August 28, 2025, the meeting of the Board of Land Surveyors has been noticed on the website since December the 18th, 2024. This month's agenda was posted on August the 15th, 2025. We'll start off with our roll call. Kevin Martin.
Here.
Tommy Young. Here. Justin Raines. See,
he may be joining us later. So it sounds like
maybe join us later.
Yeah, it looks like we got a physical quorum. And
okay, and myself.
Yep. All right. Good deal. Thank you, sir. I appreciate you getting us kicked off there. Just as a reminder, there is a notice of public comment period that will be at the end of the meeting prior to adjournment. And so anyone here or online that would like to speak during that period, they can do so by signing in here or signing on or just logging into the chat section on the online meeting, and then we'll recognize you at that time. Looks like we're good to adopt the agenda then. So, Chair. If you, we just need to entertain a motion, I guess, to adopt the agenda.
I'll entertain a motion to adopt the agenda as published.
I second.
All in favor, say aye.
Aye. Aye.
Motion passed.
All right. We got the approval of the May meeting minutes.
Are there any corrections or edits that anyone has for the May minutes? Hearing none, I'll entertain a motion to approve.
So moved.
Got a motion from Mr. Young, a second from Mr. Martin.
All in favor, say aye.
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 All right, move it along. Now, once we get the legal report, it's not going to be that fast, but
okay.
I don't want to spoil you. You're on a roll though. Just keep up the good work.
Okay. As for the professional society report, do we have someone on for that?
Anybody from TAPS online or in the building? Okay. We'll get the public comments period and see if they're on then. So, but yeah, it doesn't look like we got anybody on right now.
We may have confused them since this is a amended date.
Yeah,
on that. But so I guess that moves on to the education report.
All right, so I do have one suggested amendment to the report. You have the report in front of you. You've already seen that. I would like to add Carlson Software as the vendor. That would be course number 1325, survey data processing and plat creation for 24 hours. That's a U.S. Fish and Wildlife course done by that vendor. You have that in front of you, so it's sort of last minute addition. If you wanted to discuss it, or you can save it to the next one if you want, or add it to this one. But I did want to offer that. Jay gave it a positive recommendation. But obviously he's not here, so he's rolling off the board. And just as you're looking at that, we'll love on Jay and have him back probably November. Give him a plaque and sort of pat him on the back and give him a send off then. But so we'll see him again. But and also for those that are online, and you guys already know Mr. Young, and got to meet him yesterday. But while we're here, it seems appropriate just to welcome Mr. Young too. So we're looking forward to working with you in the years ahead, and we appreciate you being willing to serve. So it's no small task, and each one of you guys are formidable in your own right within the industry. So we'll look forward to your contribution, and if there's anything you want to say, the floor is yours. If not, we can keep trucking. But we just want to welcome you.
Well, I do appreciate this opportunity, and one of my hobbies is studying history. After the Revolutionary War, Benjamin Franklin was made the ambassador to France. And after a few years, he was recalled, and they sent Thomas Jefferson over there. And the French said, "Oh, so you are Benjamin Franklin's replacement?" And he said, "Oh, no, nobody could replace Benjamin Franklin. I am merely his successor." So I feel the same way about Jay Kaufman. I'm not replacing Jay. I'm just coming after him.
Well, we're looking forward to each one of our board members adds their own unique touch, and so we're just looking forward to your touch in that role. and representing also all of the constituents with across the state, but then geographically as well. So just, we appreciate you.
Thank you.
All right. So back, I guess back to the course at hand there. Any questions, comments, or anything in that regard? I'm not the subject matter expert, so I can't add too much as far as the content, but.
Well, I have had the opportunity to look over this myself, and but without Justin here as well, I'll ask do either of you have any thoughts or discussion or feeling about this course, because we can defer it to the next time if you prefer.
I feel like it might be a good idea, but I mean, I feel like Justin needs to look at it. Obviously, couldn't tell you what I'm looking at, so.
Any thoughts, Tommy?
So is this just an in-house course that Fish and Wildlife is giving?
It is.
Is that what this is?
Yes.
Yeah, they're using the vendor. It's the vendor is Carlson Software, but it's a U.S. Fish and Wildlife course. But they're using that vendor for the delivery of that platform. If you guys decide to defer, if we can just recommend on two folks' approvals, that way they're not waiting, till the November meeting, that I would advise considering doing something along those lines. But I know a couple of you just got it in your hand, so not expecting miracles. But Jay did a check off on it. Gary, did you have any comments, or what's your feeling?
No, to me, it looked very similar to courses that we've approved before. It's very CAD oriented, but it's specifically to survey programs and CADs and how to use them with that. So I have no problem with it myself, and would agree to approve it. But I'll defer Tommy's. We're ambushing Tommy, so I don't want to.
I'll go along with it.
Well, Tommy used to do some of the education report back in the day, didn't you, some time ago? Or
Yeah, they had a advisory committee,
Right.
and I did review some of that stuff. And
Yeah.
I did see some horrible things come through.
Yeah.
Wanting credit. I don't know that I have a problem with this one.
Okay.
Well, I mean, if that's the case, I will entertain a motion that approves the education report as submitted and adding this one, if that's what you all are happy with.
So moved.
So,
A second.
very well. We have a motion and a second to approve not only the list as printed here, which I see everything's in as a recommended for approval, and adding the Carlson U.S. Fish and Wildlife one. All in favor of that, say aye.
Aye.
Aye. Very well.
All right, thank you,
We'll
sir.
move that one off.
All right, so director's report, this is just information purposes only. The only item I have is the budget report. So mine will be pretty brief. If you pull that up in front of you, we do have, at our last meeting, we covered all the months through March. So I'm a primarily focused on the last 3 months of record, which is April through June. And then, Tommy, you see all that red at the bottom. That's because we're in off renewal year. So we always are in deficit 1 year, and then we make that up during renewal year. So you should see a dramatic shift in, we'll be back in the green next year, because that's kind of how we pay the bills. So yeah, the renewals will be at 12/31/2025 at the end of this. This is our standard biennial renewal period. And we already sent out a notice in that regard, pointing folks to our offerings and what have you. And that'll open up, I believe, 2 months prior, I think like November 1. So you'll see a shift in the budget, come January. Probably November, December a little bit, but in January certainly. All right, so you probably noticed I'm going to just hit the high points. What I typically try to do is just hit the things that stand out to me, because if they stand out to me, they probably stood out to you, And what you're looking at, Mr. Young, is primarily profits and loss charts. You've got revenues at top, that's your profits, and you got expenses down below, your losses, and then, of course, deficit or surplus. And then you've got a trend analysis at the very bottom, year end over year, so we can sort of have something to compare to, And so right now, the things that jumped out at me was, I noticed there was an increase in admin cost back charges for technology in April. And so if you were to go to April, And technology about midway down, you'll see that 3,200 kind of sitting there. It lays an egg because right before that you got like 200 something, and then 200 after, and then just April admin cost backs you've got that 3,200. So that jumped out at me. I took a look at that. That was due to a core contract. The payment reflected is for the 2025 calendar year. The invoice was not received until February of this year, and may have been delayed further due to contract negotiations. Basically, we re-upped with the vendor for core, and we were working on a gap contract, basically a maintenance contract. And so, we get invoiced for that now, so that was all coming to roost on that. So that's what the technology is, admin cost backs, and that's our proportion of it. The difference, you'll see some of the admin cost backs versus Edison expenses. Edison expenses are things itemized just to our program that are unique to our program. Admin cost backs are similar line items that are shared across programs. Like, for example, we share this building, so there's rent. There's electricity or whatever, that kind of stuff. Maintenance for the folks that service the building. That's shared across all the programs, and so that would be an admin cost back. So even though it's a line item, and our proportion is based on complaints, license numbers, the size of program. So our proportion is at 3,200, for core, since that was a shared expense across all of the programs. However, other programs paid significantly more. Our licensee counts, like 1,200, something like that. Well, Cosmo Barber is going to pay more. It's because they're sitting at 70, 80,000. MVC is going to pay a lot more because they're at 70 or 80,000. So contractors, same thing. So that's our share of it. So that contract, we expect future invoice to be received and processed in January of each year going forward. And the contract terms reflect a payment of 5 years with an option for 6 and 7, and an increase of about 3% each year. Now, a couple more things that I saw that jumped out at me. If you look at the Edison technology line under June, so you go up a little bit under Edison, that is unique to us, and you've got a technology line there, and it looks like June. Let me get up there. Okay. A lot of that appears, or at least, well, it looks more like, yeah, there it is. That's what I was looking for. Yep, that 2,500 right there. So last column, second row there, technology. See that 2,500 number right there? That one right there. That appears to be STS charges due to various project enhancements that we're working on. So, any upgrades to our application that are unique to us, and we get billed for that. We reach out to STS, and our basic STS is sort of, for lack of a better term, our geek squad. They're our folks that sort of get after our enhancements. So those are those charges for June. And then lastly, the investigations expense in April. If you go down to April and you look at investigations, which is near the bottom, you see that 4,800, hit right there. And then right after that, you've got a reallocation. Those investigation expenses were based on the program's disproportionate use of those services that month. In essence, how it works is investigations is on retainer, basically, for lack of a better term. And so depending on who's using them, you kind of take the hit, you know what I mean? So if a bunch of people were using them in April, that number would be lower because our proportion would be lower, But unfortunately for us, there was 1 month where we were the lion's share of the program, so we kind of took the hit for that one. Mm-hmm. So, but there's times we have to use them, and there's just trying to get service or whatever, and so we're not going to be bashful about it, but we try to use that sparingly for that reason, just because the model isn't perfect, but there's really not a better model. If we got to put them on a retainer, we can't send them all home and just call them when we need them. That they've got an expertise that we need in house. So,
okay. So if I understand then that the charge to us for the investigator is based on the percentage that we end up using
for that
compared
month,
to everybody
right.
else for that month. Because
right.
I was thinking usually we have about the same number of cases come in, although some of them take a lot more effort than others.
Yeah, and I saw the field notes for our investigator, mm-hmm. For that one, and so it was, there was a little back and forth, but I didn't see anything outside the ordinary,
Well,
one of our cases. So,
yeah, I've even in the one we have here, there's some fairly detailed investigations done. So some good notes for us.
Yeah. I didn't see anything else outside the ordinary. I mean, it looks like it's tracking pretty much year end over year trend. So unless you have any questions, and of course you're welcome to reach out to me. And if you had any questions, and I can always, get with our accountant or admin and look at the ledger, as we needed to. But those were the three main things that jumped out at me. If you see something else, let me know. But that's just, we don't need to vote. There's no action taken on this. Just the budget. It's just me delivering the numbers to you each meeting.
And unfortunately, I had been relying mostly on Jay being longer on boards and Jackie before him to look at these. And Jay was the one that always came up and looked at it and asked questions. Of course, then he's got fired, so I don't know. So I guess I'll have to up my game a little bit and look at these things a little closer.
So there was no investigations at all between June of last year and February? Is that what I'm?
No, primarily, yeah. We have we send out expert review. Investigations is different. Investigations is our in-house folks. Expert reviewers are the folks that we contract to land surveyors to look at the file. So those are two different buckets. So yeah. So no, we had expert reviews, plenty, but investigations would be sort of our folks to go get service. You know what I mean? Like we can't find the respondent and, or something to that effect. Or we need to do a field interview, something like that. Then we'll send out an investigator for that. All right. Okay, so it looks like we're ready for NCWS annual meeting update. I'm sorry I wasn't able to make it to New Orleans, but Mr. Clark and Mr. Martin did. So you guys, the floor is yours.
All right, it was... there's some interesting stuff went on. There's nothing that I felt was particularly new onto it. They did discuss, particularly in the southern zone, about the new mapping and science technology module that they're working on as an additional optional module to add to the exam, that states could add to the exam. They had enough folks, states, boards, request that they invest that time into it, which Tennessee was one of them that asked them to go ahead. That we're not committed to anything. This is more to give them the emphasis that there's enough people interested that we're going ahead and put something together. They did change the name from mapping technology to geospatial, which they felt they were advised that was a better representation and kept it from overlapping to the parts of mapping and measuring science that's already in the modules for licensure. We still have lots of reports where professional boards as a whole are still under attack by various think tanks that are bringing suit and all. There's still cases. North Carolina's got a couple of cases that are pending that have made it all the way, are now on the docket for the U.S. Supreme Court. That's just following on. There's similar, just more runs of these cases that actually started in California, Florida, and Missouri, I believe,
yep.
And working its way around on that. So there's nothing really to report there other than we have to be aware that there is a movement that's been ongoing here for about 15 years now to just eliminate registration boards. The only other business that really strikes me was the motion to add an MBE or MBA, I forget which way it goes, the difference between those two, to add. There is a representative already on the committee and the council at NCWS, but they're observers, not a voting member, and it was to place one on that actually could vote on things that went through. It turned out to be a hotter topic than I expected. It ultimately got deferred for some reason to the next meeting, as they were going to do some other.
Did they bring up NCARB? Because NCARB has an MBA on, they call them MBE, but they have them on their board, and so I think that's where that's coming out of. But did they talk about that or discuss that any?
It was mentioned. Yeah, it's. I think where it really went aground was of of folks asking if it was depending on the different ways different states have their directors or executive directors attached on that was I mean, some of us, well, I asked you, like you for, it would be, you weren't there, but this would have been you would have been a good example of it as you being on with several different boards instead of dedicated to one, of if that would create a conflict of some kind. So somewhere in there, they went back to go over that again. So no action other than they're taking it back to come back with a better report. As far as our, the folks taking tests and applications, that still is on a steady incline. There's more and more people testing for engineering and surveying. The difference, and they track that with two different curves. One is people who pass the test, how many pass the test, how many on the first time, and then they take it down to the second time and the third, and then multiple times on that. The slope of the line stays about the same, but the percentage who pass it and fail it, there's not much advantage to if you failed it the second time. Apparently, you're probably going to fail it the third, fourth, and fifth time too. So we're
Funny how that works, right?
it is, yeah. So it's I know in Tennessee that after 3 tries and applications, we can actually require them to appear before the board and point out how they've improved their position. So that was one of the interesting
Was
things.
that the FE or the FS, not FS or PS?
They had it for both of them. Yeah, they had it for both of them. About the same thing.
Yep.
I had a guy working for me, failed one 4 times, got licensed in another. Failed it twice, and finally passed it, so.
There was there was one thing that came up. It's called the basurveyor.com, and apparently it's the resources that NCS has in house for marketing and surveyors, recruiting surveyors into the profession at a high school and middle school level. That's something I want to be sure we pass on to, sorry, Cleveland's not on, I'll pass that on to him. That's something that TAPS ought to be interested in. And the Tennessee Surveyor Group, that's primarily what they do.
I saw the resources they have on that, and they've got some really good, quality stuff.
There's some quality stuff on that. It was too, and they're targeting the same folks that the Tennessee Surveyor Group are as well. It's the Boy Scouts, the Future Farmers, those type of things, as well as going into the schools. So
I was very impressed with that seminar, and the guy, how many people at FFA, and even I think they went through I think they showed up at a bull riding competition, various things like that, and I mean they got 8,000 people scan the QR code at one of the FFA conventions. So I mean
I didn't even think about FFA. That's perfect.
I know, that's what I thought too. It didn't occur to me, but I'm like, well, that's the perfect, people that appreciate the land and it's important to them.
it's kind of a mixed bag too, because on one hand I go to the NCWS meetings and I hear of all the legal battles we're fighting for the existence of the profession, and it depresses me. And then we have things like this where we show that we're actually reaching out and being somewhat successful of recruiting people into it. So.
ARPL's got that's a pretty good alliance, sort of pushing
ARPL,
back against that. And
They have good resources and that was a good presentation too about just what we need to be aware of and some of our responses to be and how to go with it.
I feel like you guys are in really good company with ARPL, because they really hand selected certain disciplines to protect. Instead of trying to protect everybody, they sort of grab the ones that they feel like they can make a more compelling case for health, safety, welfare. I mean, when you've got accountants, engineers, land surveyors in that group, you're in pretty good place. You're in a pretty good place. So, yeah, there's nothing that seems to indicate that I see those going away anytime soon. But
yeah, well, it's of course it's costing everybody money, but the ARPL's is actually being fairly aggressive at responding to the threats when they come in the court cases. So we have some pretty good advocates within the NCWS. Really all I had to report on that.
all right, Kevin, did he get it all out?
I think Gary did a great job. I will say that he touched on the two things I wanted to bring up was the member board expert or the administrator voting, and the attack on the various boards, I got up and asked, because it was a Florida, it had reached the Senate where they debated on it. And I asked, are you talking every board, cosmetology, real estate, they were gonna do away with every board, and it just really shocks me that you would, that's taking a chainsaw to it, it's like performing surgery with a chainsaw. I thought, it just seemed like it was really not well thought out. But like Gary said, it's been going on for quite some time now, and I was trying to think of the watchdog organization, America something, that is really heads up a lot of these attacks. So I think it's going to continue. I don't think they're done with trying it. So we got to do our best to show our value to the discipline.
Well, I appreciate you guys digging in and rolling up your sleeves and doing the work. There's a lot to sort of it's like drinking through a fire hose. There's so many seminars at these conferences, and you're trying to like capture it all. But you guys have set the bar now, because the engineers, they got to do an NCAAS report, and I'm going to compare it. And I'll let you know how they do. So, but thank y'all for weighing in and giving us an update. We appreciate that. All right. Looks like we're ready for legal section then.
Okay, I know we got some very long ones in here, but do we want to go ahead and do that before we allow thoughts or public comment? Or
It's your prerogative. If you want to amend the agenda to allow for that, then you could, or just to recognize those that are present, like if you wanted to, Mr. Franks. If you wanted to, I know the board sometimes does that, and then you would have that would be your prerogative to do that if you want.
I probably should have thought of that when we approved the amendment. Are you guys okay for waiting and listening for a few minutes? Or? Yes, sir. Okay.
Maybe longer.
Yeah. Well, in that case, if we want to we'll take a motion to amend to allow for,
they said they'd be happy to wait.
Okay.
So let's just, sometimes the legal reports are entertaining.
Okay, sounds good.
At least one of these will be, right?
I hope so, in a good way. Okay, I know this is a long one. We've got 11, I believe 10? 10.
10.
And so unless the board does not agree, I was going to paraphrase most of these to the best of my ability. Some of them are hard to do that, but I'll try.
Sure. No, I think that's, we talked about that the last time. I think that's appropriate. There is one I probably will ask you to read, just because the detail is tough.
Okay.
To keep up with.
Would that be the last one?
Yes.
Okay.
I think that's correct.
That's a good plan. Okay, well, we will get started. Number one, the complaint number is 2025011191. And this complaint is somewhat similar to a previous complaint that's been filed with the board against an energy company who works throughout North America. The energy company had requested access to a property here in Tennessee to conduct various types of surveys as part of an expansion project related to pipelines. And that complaint was presented to you guys at the February meeting this year. That complaint was dismissed, and it was reviewed by an expert. The complainant here is a licensed land surveyor. They were contacted by a property owner who felt they were under attack by this energy company who was exercising powers under eminent domain. The complainant, as a licensed land surveyor, reviewed the survey at issue at no expense, and that complainant alleges the survey is substandard and non-compliant with certain rules. The respondent states that the plat or map at issue was not a result of a boundary survey, and it was not created to exercise eminent domain, but was prepared for the purpose of seeking the acquisition of easements. The respondent does conclude and concede that certain allegations that were made related to technical issues in the survey may need to be revised. We had this complaint and all of the survey and data, everything that is related to that, reviewed by an expert. And the expert did find some technical issues. Respondent offered up some GPS information, but did not include all information required for remote sensing surveys under Rule 0820-03-.075. The expert's opinion was that a Category 4 certificate would have been more appropriate than a Category 1 certificate for the work product at issue. The expert concluded that the expert concluded that the work product at issue may not require GPS notes and accuracy statements, but notes that respondent did partially include them and with an incorrect accuracy statement. So based on the expert's findings, I recommend a letter of instruction laying out these technical issues found as a result of the expert review.
Thank you. Just for my own clarification, I always have to have this clarified. We have disciplinary action that we can do, but then the two different letters, is it a letter of caution and a letter of instruction?
Those are the same thing.
It's the same thing.
Right. Letter of warning is a little more, I guess, invasive because we kind of think that maybe there's something to the allegations, but we don't have clear proof. So we're just giving them a warning in case they might do the same thing in the future and it might be a violation. Whereas a letter of instruction is more, here are the rules. We just want to remind you what they say. So please be aware of them as you are surveying.
The warning is a little more tougher on it, I guess.
Yes, but neither one are reported to any states or agencies.
Right.
Only
that doesn't get them to the point where they have to check that box when they're doing renewal that
right.
they have something.
Right.
But it is, either way, it is something that goes into the record, and if the same things came up later, that we would draw back on and saying that we have a repeat.
Exactly.
Okay.
And like we reminded you about this issue, or possible issue, and we have that for our personal records.
Okay, so the warning is harder, the instruction is a little softer onto it. If y'all don't mind, I'll speak to this very quickly onto it. Is one of the things I like about the way these reports come in, they're usually thorough enough with some of the candid information that I can just about visualize what went on in the process on that. And particularly this, since I do a lot of work for energy companies, and it's a tough run for the surveyor because they are and sometimes into eminent domain. The public does feel like that people are stealing their property, and we're out there on the point of the spear standing on their land.
Right.
And so a lot has to work with how you go to it. And I can also see where so often these are the type of clients that will give you a template of how your product is supposed to look, including the notes that they'd like to see. And of course, our standards of practice still overrule any of that. But I understand the pressure that the surveyor gets in by both the client, the attorneys, the owner's attorneys, everybody wanting to edit your drawing to make them happy onto it, which is fine. We're good guys. We'll try and cooperate, but we still have to remember that to have to meet the standards of practice, and when the product comes to us, regardless of the motivation how it gets there, I feel like we just have to do that and go with it. If he left these particular notes off, and I can see how that would happen, it could be a combined survey. I don't have any problem with saying it wasn't a boundary survey. I know what he's saying there. He wasn't trying to fix the entire boundary. He's just trying to get enough of the boundary to get the easement in. And that's perfectly fine in my mind. I want to send him a letter, and I'd almost go to a letter of warning instead of a letter of instruction, but we'll talk about that. And my reasoning for this is one, it makes him understand how serious it is that he does meet the minimum standards, regardless of the pressure he's on to modify it, but it also gives him something to wave back at the folks pressuring him, saying, I ain't going to do it because this is what happens.
That's a good point.
And so for me, certainly want to send him a letter. I would favor going to the letter of warning.
Okay.
Thoughts, Tommy?
Neither letter has any legal ramifications long term, so It's almost 6 of one, half dozen of the other, but yeah, I'm fine with letter of warning if that's what we need to do.
Yeah, I gotta tell you guys that the microphone don't pick up your head moving, so.
I think I agree with Gary. I think he made a good point with, it's as much a tool for them to show the people applying pressure that, hey, look, I can't do this because this has happened before. Can't let it happen again. So I feel like that's the better decision.
Okay, do I have a motion to that effect?
I make a motion that we change that to a letter of warning.
Second.
In the fall favor?
Aye.
Aye.
Okay.
Okay. Number 2, complaint number 2025020721. Complainant claims an individual hired respondent to survey and prepare a subdivision plan for a named subdivision and to represent that individual before the County Planning Commission. Complainant remains anonymous, and it is unclear how they are involved in this matter. The complainant alleges numerous local regulations were ignored and alleges some deficiencies. The respondent believes this boils down to the fact that some neighbors of that individual who hired them do not want to see their land divided. Respondent denies disregarding any regulations. They work with multiple county and city planning offices frequently. Those offices wouldn't let the regulations be ignored either. An expert did review this matter in full. It included 79 pages of documents related to the allegations, as well as the response and all documents related to the surveyed issue. The expert found no violations other than noting the north arrow on the preliminary plat is missing its source. The expert notes this information needs to be added before the plat is approved. So my recommendation based on that expert's findings is to recommend to issue a letter of instruction laying out just the technical wording that the expert mentioned in their report.
All right, this, again, to me, this seems like the surveyor's caught into an argument that's not his.
Very common.
And that they're using, and it happens a lot, they're using him. Somebody has recopied part of a plan to use it as a low resolution copy that they're working with. I don't see anything here that they're all right. The problem with the labeling of north there, whereas the rules do actually say that the north arrow will be, that you will clearly indicate what the basis of the bearings on the north arrow. Some people do that by note, and it's, to me, it's a little bit ambiguous there whether or not you fulfill that with the GPS note that explains everywhere you got your grid or other notes of it. Just for safety's sake, I always label a north arrow. I think a letter of instruction would be plenty for this, just to mention to be careful, because we do have to be aware. It's sometimes it's not the experts bringing these things in; it's the public and their perception. So,
Right.
thoughts?
I agree with you.
Okay.
I make a motion to accept the letter of instruction based on the recommendation.
Second.
All in favor? Say aye. Very well.
Okay. Number 3, complaint number 2025024061. Complainant initially reached out to respondent to inquire about getting a property they owned subdivided so each duplex could stand alone on its own lot. Complainant asked respondent if they could determine whether it was possible per zoning restrictions. After some back and forth, respondent told complainant it would be impossible and it could not be done even with a variance. So complainant hired a different land surveyor. Complainant says they spoke with the county zoning office. Complainant's basically claiming everyone disagrees with the respondent, and the complainant also notes that they owe the respondent money and feels that that might be part of the problem here. The respondent does confirm the complainant hired them for the purpose of surveying a piece of land and dividing it into 3 sub-parcels. Complainant met with respondent. They went over everything. The work was done. But what it boils down to is respondent believes this complaint was filed because the complainant doesn't want to pay that money that's owed and wants to lay some groundwork for non-payment in case respondent tries to claim that money in court. Respondent is 87 years old. They've been surveying for 54 years without issue. Based on what the complainant provided me, I couldn't find any evidence of any violations. So I recommend dismissal.
I would agree. It sounds like an unfortunate situation for all involved, but I don't see anything that's actionable by us on this. I would agree with dismissing it.
Make a motion to accept the legal recommendation to dismiss.
Second.
All in favor, say aye.
Aye.
Okay.
Okay, number 4, complaint number 2025-021-781. Complainant's neighbor hired respondent to survey their property. Complainant claims respondent also surveyed their own property because it was in relation to a fence boundary issue. I want to note complainant lives in another state, very far away, so they weren't there during any of this. But complainant's son-in-law and daughter were at the home and did talk with the respondent. Complainant did speak to respondent on the phone and stated they would pay the $250 fee related to their neighbor's survey cost because there was an encroachment found. But complainant basically argues they never actually hired respondent, although they concede that maybe their son-in-law and daughter agreed to, make a payment and allow respondent to do some work based on this encroachment. So respondent confirms that the complainant's neighbor hired them because they believe complainant's fence was on their property. Respondent went over all of the costs that could be associated with this. That neighbor agreed to them. He moved forward. Respondent did make it clear to the complainant and their own client that each party was responsible for their own bill. Each job was separate. I just don't find any violations here. I think this is just an argument about money. So my recommendation is dismissal.
I agree. I don't see anything in here that is actionable by us. I guess I will just say, just so it's on public record, that he could have saved himself some grief probably with a contract starting off.
Right.
Which is something that we try and advocate on the professional organization level all the time. I would agree on the dismissing it.
So I have a question. Obviously, the board doesn't get involved in contractual issues like this.
Correct.
What if there was evidence of fraud on the surveyor's part? In other words, what if there's a signed contract that he's going to do this and he never delivered the work? Is that something we can?
I think that would be something that could be considered general.
Ethics.
Yeah, like
Okay.
in our ethical portion
Sure.
of our statute and rule,
Okay.
it's kind of broad and left to the board's discretion. And I think if somebody pays for something and the work isn't done, that could fall
Right.
under that, and we could
Okay.
take action.
Okay, we don't have anything like that here, though, so.
And up to including a criminal referral, like if it was like a crime, then
Right.
we would just, we could refer to the
Right.
appropriate authorities. But, it'd be outside the board's jurisdiction at that point. But,
Sure.
the legal made a great case, talks, anything within the ethics, that standards of practice or
Okay.
whatever.
Well, I'd agree to dismiss.
I make a motion to accept the legal recommendation to dismiss.
Second?
We have a motion and a second. All in favor, say aye.
Aye.
Moving on.
Okay, number 5, complaint 2025035431. Complainant hired respondent to survey their property in October of 2024 so they could sell it. Respondent began the work in the middle of November. They told the complainant they weren't finished in late December and kind of said that the property was a big mess. Complainant states the biggest problem they have with the survey is that instead of coming to them to ask about property lines, complainant claims that respondent kind of spoke more about this with their brother. So complainant states they are being charged $11,000 for a survey that includes items they didn't ask for. They feel respondent should be charging their brother instead of charging complainant for the full amount. There is a lot of detail that I've laid out in this legal report relating to the family kind of dividing this land. There's issues with an heir that's a minor. I'm not going to go into all of it unless the board has questions about it. But basically, complainant did pay $7,500. They're still waiting for the final survey because respondent insists that all parties must sign off on the work product related to the land owned by all of these different family members to show that they're in agreement. I completely agree with that. There's a conservatorship now at issue here with the minor heir, and that has kind of slowed the process down. The respondent sent the billing statements knowing how long this is probably going to take. I don't see any issue with that either. And I believe that there's a lot of frustration within the family that shouldn't be put on the respondent here. I think they've done their job. They've done it well. They've communicated the best that they can, considering all of the different opinions they're probably hearing. So I didn't find any evidence of any violations, and my recommendation is dismissal.
Yeah, it's a good report, a lot of detail into it. It does seem like most of this is just family problems and things, and we hit this fairly often in complaints where the client will complain that the surveyor talked to the neighbors instead of him about the property. They can't put that restriction on us. We talk to whoever we need to and gather whatever evidence we need into it. No, that's not there. The only thing, and sometimes we take a job and once you open it up, it turns out to be way more than what we thought. Again, on this, I'd say that, either contract, this is something I would certainly been notifying everybody of what was going on in writing, particularly additional charges that were happening as we went. But that's not really in our purview, I don't think, just advice onto it. I would go with a dismissal as well.
I agree.
Make a motion to accept the legal recommendation to dismiss.
Second.
All in favor, say aye.
Aye.
Okay, number 6, complaint 2025-026-821. This complaint was opened as a result of respondent self-reporting discipline that occurred in Nevada. Respondent resides in Oklahoma. They're a licensed surveyor in multiple states, including here. The discipline arose after respondent failed to file with the county recorder a record of a survey relating to land boundaries and property lines within 90 days after the establishment of points or lines. Respondent did admit to failing to record the survey at issue within 90 days as required there in Nevada. There was some other just kind of allegations that were included in their signed agreement that related to the responsible charge and quality control concerns that I think the state had, but the respondent did not admit or deny those allegations, and the state didn't provide any proof or any detail in the agreement that could lead me to believe that any serious discipline is warranted here. The respondent did voluntarily relinquish their license there in Nevada. They paid a $5,000 fine. They paid legal costs and investigative costs. They notified us soon after it happened. They state that they're winding down their practice. So based on all of that, I think a letter of warning is probably the most appropriate discipline based on 62-18-116A1F, allowing the board to take disciplinary action when another state issues disciplinary action to a licensed land surveyor.
This one makes me feel uneasy, but I don't find anything where I can actually put my foot down.
I agree.
Onto it. The very fact that he's trying to maintain 34 licenses, the amount of time that takes to be sure that you're using the correct standards for that particular state would be more than what I'd want to take on. But again, he may be just smarter than me, and I can't find anything that I can issue him on except I would agree with a letter of warning that regardless if he's going to practice here, he better read up on our standards. So I would agree with a letter of warning in this case.
I agree.
I would agree with that. It looks like he's paid, a fair amount in his administrative fines and legal costs, and he's self-reported. Seems like he's making a pretty good attempt to do the right thing. And I'm not sure how egregious the error was in itself. What's your opinion on that, Gary? I mean,
Well, there's just not enough there to really say.
Right.
To it. That's the problem in it. The most I've got is that, I mean, because some people, and there are instances that we've been aware of, I mean, long before I came on the board, of folks doing stuff that was clearly illegal, but the fines weren't enough of a deterrent to stop them. They just
Right.
paid the fine and kept working onto it, and that could be it here. It was, he made enough money on whatever he did, they just wrote a check, handed him a license, moved on to the next state. I mean, that's possible in there, but I mean, there's no direct evidence of that. It may have been more, I'm not doing much in Nevada, it's easier
Yeah.
for me to just say, fine, I'm gone, and move on of that. So, the best I can come up with, and the warning is stronger than the instruction, but it's not really any disciplinary, it doesn't really follow him around, it's just kind of us putting our flag in the ground that if you're going to come across this line, read our standards, please.
Yeah. Other states, especially those in the West, require surveys to be recorded in the public records. And that's all we've got here is he didn't record the survey, which in my mind is not a very serious offense.
right.
There's other things that went on there, but we don't know anything about that. So
Right.
I would agree with the letter of warning.
Okay. Somewhere in there, is there a motion?
Oh,
I make a motion to accept the legal recommendation of a letter of warning.
second.
All in favor, say aye.
Aye.
Very well.
Okay, the next two are related, and they're also related to a complaint that I presented at our last meeting. Number 7, the complaint number is 2025-029-721. And the complaint here, like I said, is related to the next one I'm going to go over. Both of these complaints were opened at your request when I presented the original complaint in May. I'm going to give you enough detail, though. This might be longer than you want it to be, but I think a lot of this is important, and I want to remind you, and especially for our new member.
Please do it.
Yeah.
I remember the other two cases and referred to them, and this is just a continuous loop. It keeps going
Right,
around.
right. So I'll
Just-
probably give you more than you want, but I think
It's-
that that's helpful, especially, like I said, with somebody new coming in. And if you have any questions about the last meeting or just you want more, let me know. Respondent is a licensed land surveyor. Respondent is the one who filed the original complaint that I presented in May. They filed it against an individual who was attempting to become a licensed land surveyor after taking over their deceased cousin's land surveying business. That individual had worked for the business for like 13 years, wanted to be a licensed land surveyor, has not been successful, has taken the exam like 4 times that I know of, and still is not licensed. So respondent was going to merge their own land surveying business with this individual's. They did a proposed merger agreement. During that time, the respondent agreed to look over and sign off on some plats. Specifically, I believe it was 17 surveys that were performed by that unlicensed individual. Let's see. Well, that happened on January 31st, 2025. This respondent did sign approximately 17 surveys performed by the individual. This complaint was opened under the possibility that those actions might be in violation of the rule that prohibits somebody from acting as a responsible charge of 2 or more companies not at the same address. Respondent, kind of their argument here is that purpose of that rule is to keep a surveyor from signing plats for 2 or more businesses with the intent to profit from separate businesses. The fact here showed that respondent was acting within a narrow contractual time frame regarding their purchase of the individual's company. Respondent argues their actions in signing those plats were not part of their regular business practice. They were intended to help keep this individual's business afloat. They were accomplished under the guise, whether true or false, of keeping the payroll going for those employees at that company. Respondents' actions were based on the goal of acquiring the business, keeping those employees on staff. Their workload was big. There was never an agreement for respondent to sign plats for the individual on a regular basis. So the respondent does ask you to take into consideration these kind of unique circumstances. The respondent also asks you to take into consideration the monetary loss they have already suffered because they have had to assist clients that needed surveys corrected. They've done that work for free. They've already done 4 separate surveys that have been completed by that individual. They believe more are to come, and they will fix those for free as well. They also ask you to consider that they self-reported this problem. They did it wanting to request wisdom and advice from the board. That was the purpose of the complaint. It was not intended to get this individual in trouble. They also ask you to consider that the rule surrounding the responsible charge can be somewhat confusing. Let's see, even they note that the chairman at the previous meeting, who's not here anymore, stated that they quoted that the responsible charge rule is definitely a misunderstanding amongst the industry. It comes up with discussion to the chairman, the previous chairman, from time to time. I'm sorry, he was the chairman a while ago, not at this board meeting. Okay.
I'm about to say I was chairman when this thing
Yes,
came
I'm
through,
sorry.
so
This
that's
is not
what-
you. This is Jay
No,
Kaufman.
Yeah, you can
Okay.
take me out of this chain if you wish, but I'm afraid I was the one that made that statement.
No, it was Jay, I believe. I believe.
No, I made that statement.
Did you? Okay, so it was okay. So I'm just confusing the issue here.
That's fine.
But was you?
Yeah.
Anyways, all of those unique factors, the confusion around this rule, the respondent asked you to take those into consideration. Also, the respondent was never claimed to be the responsible charge. They were just assisting. I don't know if that makes any difference to you, but that's part of the argument here. So the unlicensed individual who the respondent filed this complaint about, that owned this company, they have since accepted responsibility for their actions, their part in this. They paid a $2,000 civil penalty, which you assessed at that May meeting. I believe that a distinction should be made when a surveyor, such as the respondent here, is not holding themselves out to be the responsible charge for a surveying business. We have seen many complaints where that is the situation. They're claiming to be a surveyor for the responsible charge for their own business and another business at a completely different address. They've been doing it for years, maybe on a regular basis. That's not what happened here. I also believe it's a mitigating factor that they brought this to your attention without an ulterior motive, which I've also seen in the past. I just don't see that here. So I recommend a letter of warning because I believe respondent did act in a way that could make it appear they were acting as a responsible charge for 2 separate surveying businesses.
Okay. I'll summarize some of the past things, mostly for Tommy's benefit since he wasn't there. This was a very confusing case where, I guess the gist of it was there was relatives involved, and he was really just trying to help each other out and help a business that had unexpectedly lost their responsible charge surveyor due to death.
Right.
And it was just kind of a come together of the community to help them stay together long enough for the plan where they had one guy who was in the pipeline and should have been able to get his license within a few months.
Right.
And just hold it together a bit. One, it does hinge on to a lot of complaints we've seen come in about people being in responsible charge who's not an officer. My statement, and I still stand by it, is that is not what the intention of that rule was when it was written and put into that. And I know that but the fact that it's coming up with some ambiguities now shows that, okay, whatever the intention was, we need to get it reworded and fix these ambiguities. And we have that on our agenda to do. So I'll stay kind of light on that. The fact that the guy they wanted to get licensed has failed the test a few times. I've already mentioned the statistic is that if they fail it twice, they're probably never going to pass it. And that's what's hurting their problem now. this. So I see a lot of this. I mean, in the situation, even though the guy who the complainant, we find the complainant and everybody else because they were all in violation. He even said he was in violation. We did that. I think we need to give them a little bit of a emphasis here, that encouragement that they need to resolve this thing. They probably didn't mean it to go on this long. It's gone on this long. It's going to become a danger to the public. They need to fix this thing shortly and move on. So I would go with a letter of a warning, but if it comes back up, it's not going to be pretty.
Right, I completely agree.
Yeah, that's my thoughts on it, Tommy.
So, boy, this is a little confusing.
It is very confusing.
The original,
It's even harder to write when it has to be anonymous and
Yeah.
you can't give any detail. So I did my best here, but I'm happy to answer any questions you have.
person one, person two.
Right.
Yeah.
So, who filed the original complaint? Was it the licensee against the unlicensed person?
Right.
Okay, and who is this?
This
Oh,
complaint
this
is
complaint.
against that licensee that filed the complaint because the board wanted it opened. Once I brought
Okay.
all this detail to them
So
in May.
the board filed this one?
We were given the complainant, the complainant a break. He self-reported all this and acknowledged that he was admitting to possible wrongdoing on his part.
That was the licensee?
Licensee.
Okay.
He admitted that that this was probably improper. He went through the motivations, the fact that everybody, in my mind, and the board was trying to just help everybody else and get over this hump of the unexpected death of the
Right.
surveyor, and we've seen that before. But now it's coming back around. I guess that is, we wanted it stayed open to make sure that they did resolve it.
Yeah, and I think we weren't, when I originally presented this, we didn't have enough information as to whether this licensee who filed the complaint was like really holding themselves out to be a responsible charge for two companies, how much they were involved with both. So I think the board, their intention in having me open this complaint and the next one was just to get a little more detail and make sure anybody who needed to be held responsible was. So this is me just providing that detail.
Okay.
Yeah, I think he is now clearly in violation. He's let it go on too long, and he is trying to be responsible charge for too many places. So that's why I would, at the very least, want to say a letter of warning that he needs to quit that and resolve this situation. Now, it's been,
So,
it was nice of him to wait for.
He's not been involved. He stopped being involved though, like before, before
I was gonna say,
this.
so he's not doing this anymore? is
No. The merger did not happen. Once he got involved in this business, he felt like there was maybe some unlicensed activity going
Right.
on. So he separated himself after this, he did that kind of pile of plats
Right.
in that January, that date I gave you. After that, never did anything else, separated himself from the company. The merger was canceled, and I'm trying to think I think maybe the complaint was filed right as all of that was happening.
Okay.
And he was kind of asking for wisdom about all of this in his own words.
Okay, so this basically involves his actions during that time
Right.
period and not anything since.
Right. And then
Okay.
and that led to the punishment, a $2,000 civil penalty against that unlicensed individual
Okay.
who we believe was engaging in
Right.
unlicensed activity and never filed firm disclosures, after their cousin died about who is the responsible charge. So that person was punished. And now we're just kind of wrapping it up.
Okay.
So he's saying that he was wrong, and we're just agreeing with him.
Right.
Oh, well, I mean, if he thinks he was wrong, who are we to argue with him? I mean, I'm fine with a letter of warning based on that.
Again, it's another case where this may give him the leverage he needs to distance himself from this mess.
Right.
He's tried to, no good deed goes unpunished.
I mean, this sort of goes back to the pipeline deal. This is basically verification from the board
Yeah.
that he is wrong and not just his word to others that he was wrong.
Right.
And I think putting it out there that that business is not licensed and they were trying to still do surveying and putting that on the record and making sure they were held accountable for that too. which we did.
And I think it keeps us consistent, particularly in this case right here.
Very.
We need to stay consistent in
Very.
our path right here.
Right.
Because it's probably not done yet.
I hope that they're not still surveying.
Somewhere there, do we have a motion or more discussion?
I make a motion, we accept the recommendation of a letter of warning.
I second the motion.
All in favor, say aye.
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 Okay, so number 8, complaint 2025029-741. So this is also part of this situation. The respondent here, the licensed land surveyor here, was assisting this unlicensed individual's business before the last licensee we just talked about came on board. They actually called the board. They said, I don't have any names of anybody who they talked to, but they called the board and asked for permission when the cousin originally died, said, can I help, this company, can I sign off on the plats? They said that they were told yes. Another reason we opened this complaint at the board's request is I was not sure if they were acting as a responsible charge for their own engineering company. And once I opened this, I found out that they were absolutely not. So they were only working as a surveyor for this unlicensed individual to help them out until their own eyesight started to fail, and they stopped. And that's when the licensee that we just talked about started assisting. So that's all there is to this complaint. I didn't find any evidence that they were acting as a responsible charge for two businesses. They worked at least 30 hours for this business while they were assisting, and that's really all there is to it. So I recommended dismissal of this.
And I'll add to that Jay and myself independently made a number of calls to past board members and trying to find who this fellow talked to that he claimed he had advice that he could do this. We can't find anybody. It either didn't happen or it wasn't really a board member or they're not owning up to it.
Right.
We don't have any that have passed away recently that would have been in there. So,
and this would have happened 5 years ago.
yeah, so he may not have been talking to a surveyor board member. He may have been somebody else on
He
that.
may have called a TAPS chapter
I was going to say it
secretary.
could have been somebody from
We have
TAPS.
that a lot where they said, well, I called
Right.
talked to the board of directors, and they're talking about the TAPS board directors
Right.
instead of us. So that we didn't poll that group. But, yeah, I agree this is a dismiss.
Yeah, I'll make a motion to dismiss.
I second the motion.
All in favor, say aye.
Aye.
Okay, we're getting there. Number 9, 20250333801. Complainant states they met respondent, a licensed land surveyor, on June 6th of this year, while that surveyor was surveying a farm adjacent to their own land. Complainant and respondent discussed various things. Complainant alleges they noticed an open container in respondent's vehicle and smelled alcohol. Complainant alleges respondent stated, I'm not drunk, I'm just thirsty, when complainant addressed the alleged alcohol container. Respondent does confirm they had a beer in their vehicle. Respondent states they were grilled for information regarding a private easement by complainant. They talked through it. Respondent states the temperature was in the 90s that day. It was around 2:30. They admit to taking a drink of their single Michelob Ultra that they had just bought. They state that they shot 2 posts at the end of the road and near or on the property line. That's all they did that day. They came back the next morning and did the adjoining farm. Respondent states that he is 75 years old. He's been thinking about retiring, but has not because there's not enough surveyors in that area to keep up with the demand. Respondent states they will retire if the board thinks they need to take their license away because of this. Now, I feel the appropriate action in the situation would have been for complainant to call the police or file a police report if they wanted to move forward with these claims against respondent. I'm not saying that the board condones drinking and driving. We absolutely do not, but we don't have jurisdiction over crimes like that. We don't have any evidence of issues with the survey. We don't have complaints from the person who hired this surveyor. I just don't have enough evidence here to even hold them accountable for anything. That would have been something proper for a police officer to do. So although it's disturbing, I recommend dismissal.
There's no malpractice allegations in here.
Right.
It's just about, well.
If there were, it would be a different story.
Okay. Then I think we should dismiss it.
And, this person has been surveying, they've been licensed since 1981 without problem.
I'll make a motion to dismiss.
Well, I don't know. Just look like I said that. I almost want to send him the letter of instruction and just say, please don't do that. And please
We
don't
can
say
do that.
Don't say that to the public.
We can absolutely do that.
It's certainly not a malpractice, but I think it borders on some unprofessionalism here.
I agree.
To actually being that probably doesn't quite get to ethics. It's just it doesn't look good for the profession as a whole. And I think I don't know. That's the only thing I would throw out, and maybe just saying it here to the open air is as much as we can do. Is that please don't do stuff like that or say
Right.
that to anybody. But I don't know.
That's a good
That's
point.
what I kind of.
I retract my motion.
I think that's actually a really good idea, letter of instruction. We have it in the record here. We're giving some unsolicited advice about driving, being in the car with alcohol while you're possibly surveying.
Just be aware of you're a professional.
Exactly.
You're supposed to. The public gets to expect a professional to act differently
Right.
and perform differently. Is it? I have other more colorful words in my margins right here, but we probably don't want to use that. But I think at least a letter of instruction I don't think doesn't do him any harm. It just points out that how we feel about the profession.
Right.
Well, we don't have a motion.
I know. I'm under the opinion that, Chairman, I don't need to make the motions. I need to.
Okay, so I'll make a
And
motion.
these guys keep shaking their heads, which the microphones don't pick up, so.
I'll make a motion that we send a letter of instruction recommending the licensee be more professional.
I second that.
All in favor, say aye.
Aye.
We'll trust on your skills, Erica, to come up with good ones.
Thank you. Thank you.
I thought it was
Not
funny
gonna-
that he said, well, it brings up the Michelob Ultra, then he said he shot 2 posts, and I'm thinking,
Right.
it sounds like something you do after.
Right. Well,
Well,
There's a different kind of shooting of posts.
in all fairness, we don't know if he actually didn't use a gun to shoot those posts.
That's right.
Right.
It didn't, I know, right?
well. Now the next one, I believe we would like for me to read verbatim.
I really would I know it's a little long, but this
Well,
has got a lot of stuff in it.
I am happy, and I believe there's going to be quite a bit of discussion. Can I just have a couple minutes break really quick?
Sure.
Okay.
We'll take a 5-minute break.
All right, thank you.
We will resume our meeting right now. I've just been informed that we are having technical difficulties and people are having trouble logging in. So if you are trying to log in to make a public thing, that's the problem we're having right now. And I apologize. So, all right, Erica.
Thank you for the break. I appreciate it. This is our last one, number 10, complaint 2025-034-961. And like I said, I'm going to read this verbatim. Complainant is a licensed land surveyor and respondent is an unlicensed individual who owns a company here in Tennessee. Respondent's company specializes in 3D LiDAR scanning, drone services, and building information modeling drafting. Respondent provides precise spatial intelligence and digital imaging solutions for government, utilities, and the architecture, engineering, and construction industries. Complainant alleges they have been seeing respondent's company advertised on social media and claims they are offering services that fall under the definition of land surveying. Respondent claims their services are perfect for large construction sites and hard-to-reach areas. Their website states that they offer services to include drone surveys and inspections. Respondent has since changed this to drone services and inspections. That particular tab on their website states Elevate your perspective with our comprehensive drone services that use cutting-edge technology to provide real-time data capture and imaging like never before. Through leveraging high-resolutions photogrammetry, we provide precise topographic maps, detailed orthomosaics, terrain mapping, and aerial inspections, offering a comprehensive set of solutions for aerial data capture. These products have proved to be invaluable for everything from documenting large construction sites to inspecting towers or monitoring difficult to reach terrain. Respondent has since changed this wording substantially, as noted in the response I'm going to summarize. Complainant provided a screenshot from Respondent's website referring to a specific project completed by Respondent titled Site Survey with Topo. This screenshot referred to a scenario where a landscape architecture firm required an accurate site plan with 1-foot topographical lines for a 25-acre property featuring a large central hill. Respondent explains on their website that they conducted a site survey using a special drone enhanced by survey-grade MLID base and rover system, which is a special drone kit, for on-site true RTK location correction. That, based on my little bit of research, offers a reliable method for achieving high precision positioning in a variety of applications, from surveying and construction to agriculture and drone mapping. Ground control points provided geolocated orientation for the scan data. Respondent's drafting team then utilized Revit to assemble a precise topo map, including existing structures and drive locations. As part of the terrain mapping mission, hundreds of drone images were also captured. Respondent was able to provide 2D drafting of site plans with and without point cloud imaging in PFD and DWG formats, high-resolution drone images, and raw point cloud data. The drone scan produced a topo map of the property that exceeded traditional topo survey accuracy in less time and at a reduced cost. There is a note on the website that states property boundaries can also be incorporated into our site surveys if requested in advance. I will note that that's also been changed on the website, and all of the changes that I've mentioned were made after the complaint was filed. The note now states legal property boundaries and certified elevation data were available as an upgrade through our partnership with the licensed land surveyor. Additionally, there is further clarification on their website stating, while the data was not certified, the drone-based analysis produced a detailed topographic study of the property with precision comparable to traditional survey methods, completed in less time and at a lower cost. Respondent states they have been transparent in all client interactions through proposals, deliverables, and conversations, that they are not licensed land surveyors since the business started in 2023. Respondent explains the company has recently expanded into drone services, which include capturing images, video, and photogrammetry data for clients across various industries. These data assets are used for general visualization, conceptual design, and non-certified terrain modeling. Respondent states they do not provide property boundaries, determine legal building locations, or certify elevation references. Respondent states they partner with licensed land surveyors wherever or whenever certified data, like legal boundaries, elevation verification, or building placement is required. Respondent has made the changes to their website to reflect this as summarized, like I just summarized above, those various changes. Specifically, Respondent did add this wording: when certified elevation or boundary data is required, we collaborate with licensed land surveyors to ensure accuracy and compliance, delivering complete aerial imaging solutions for construction, infrastructure, and asset inspection projects. Respondent states they have consistently communicated to clients that they do not provide certified boundary or certified elevation data without involving a licensed land surveyor. Respondent did provide me with a screenshot of an email showing this clarification. Respondent also provided me with a previous project proposal that includes fees for a licensed land surveyor to complete a legal property boundary survey and driveway location. To date, Respondent has not undertaken a project that required formal collaboration with a licensed land surveyor. Respondent states they're committed to building a company grounded in integrity and dedicated to delivering exceptional service. Now, complainant, as I mentioned, they're a licensed land surveyor. They provided a very detailed rebuttal to this response that I just summarized. They argue that respondents' operations squarely fall within the statutory definition of surveying under Tennessee law and closely mirror a case already decided in federal court. Now, here the council notes that Tennessee defines land surveying by function, not by label, and they quote our statute that defines it. And I have to apologize because I didn't correct the complainant here when I wrote this legal report. I just kept what they quoted in here, and the statute as it reads does not state what I quoted here. They pulled that from the court case and from a different state. It was either Mississippi or North Carolina. It's similar, but that's not our definition. So to correct that, I'm going to read what our statute defines land surveying to be. So TCA 62-18-1023 defines land surveying, the practice of land surveying, in the following way. The practice of land surveying means any service of work, the adequate performance of which involves the application of special knowledge of the principles of mathematics, the related physical and applied sciences, and the relevant requirements of law for adequate evidence to the act of measuring and locating lines, angles, elevations, natural and man-made features in the air, on the surface of the earth, within underground workings, and on the beds of bodies of water for the purpose of determining areas and volumes, for the monumenting of property boundaries, and for the platting and layout of lands and subdivisions of land, including the topography, drainage, alignment, and grades of streets, and for the preparation and perpetuation of maps, records, plats, field notes, records, and property descriptions that represent these surveys. So that is Tennessee's definition. Complainant argues that our statute is deliberately broad and technology neutral. Complainant argues the use of drones, LiDAR, or photogrammetry does not exempt a company from licensure if the resulting work serves the functions defined in the law. Complainant believes that respondent services, including 3D site modeling, terrain mapping, topographical plans, and construction documentation, clearly fall under this scope. Their data appears to be used for design, development, and construction planning, all of which are functions reserved for licensed surveyors. Complainant points to two recent legal cases out of North Carolina and Mississippi to support their arguments. The cases are as follows. The first one is out of North Carolina. It's 360 Virtual Drone Services, LLC, versus the North Carolina Board. This case involved a company offering drone-based orthomosaic imagery, terrain models, and elevation products. The company claimed it was offering visualizations and not formal surveys. The North Carolina Board of Examiners for Engineers and Surveyors found the company was engaging in unlicensed surveying. The district court for the Eastern District of North Carolina agreed and stated the professional licensure requirement is aimed at the function and use of the data produced, not merely the provider's intent or disclaimer language. And that case was decided in 2023. The second case the complainant references is out of Mississippi. It's Visaline LLC versus Tracy. In this case, Visaline created GIS maps of real estate boundaries using legal descriptions, but without being licensed land surveyors. The Mississippi Board of Licensure for Professional Engineers and Surveyors determined this was unlicensed practice. Visaline filed a lawsuit arguing that its mapping was free speech, basically alleging First Amendment violations. The U.S. District Court rejected that argument, ruling the state's licensure laws regulate professional conduct, not protected expression. The federal courts upheld the board's authority to restrict unlicensed mapping when the product influences land understanding, planning, or boundaries. Complainant argues that these rulings make clear that the use and application of spatial data, not the company's disclaimer that they are not licensed land surveyors, determines whether licensure is required. Tennessee's definition of land surveying, as I just read out and as stated in our code, is nearly identical to those in North Carolina and Mississippi. All three states define land surveying by its function, mapping and interpreting data about land, not the tools that are used. These two federal cases confirm that licensure laws are enforceable and disclaimers do not exempt companies from those obligations. Complainant argues that following the lead of these states directly supports the Tennessee Board's mission of public protection and professional integrity. Complainant further argues that respondent services are functionally identical. Respondent asserts that they avoid offering, quote, certified data and inform clients they are not licensed surveyors. However, as in the North Carolina case, respondent provides topographic imagery, terrain modeling, and site plans. Respondent's outputs depict the shape, elevation, and layout of land. Respondent's clients appear to use these for planning, design, or decision-making. In short, complainant argues that their data functions as a survey. As the courts have affirmed, that makes disclaimers irrelevant. The use and outcome of the data, not the title given to it, determines whether licensure is required. Complainant, as a licensed land surveyor, requests that there's a formal board action in light of the similarities between respondent services and those ruled illegal in the North Carolina case. Complainant requests that the board conduct a formal review of respondent services, proposals, and marketing materials, evaluate whether respondents' outputs constitute land surveying under our statute. They ask that you consider the two cases I summarized as persuasive authority. They ask that you take the appropriate enforcement action if unlicensed surveying is found to have occurred. Complainant further emphasizes that this complaint is not about stifling innovation, but is instead about protecting the public, preserving professional standards, and ensuring that companies do not sidestep licensure by rebranding their services. Complainant argues that the federal court's rulings in these cases cited above confirm that this type of activity cannot legally proceed without a licensed professional involved. Complainant further argues that Tennessee has nearly identical language and now it has multiple legal precedents to guide enforcement. So I recommend that you discuss this. I think it, obviously has, I think there's great arguments made here. I think it's what we decide is gonna really affect, anybody else using drone services. I think those are becoming more and more popular. Disclaimers, I think, is a really big factor in people offering services that aren't licensed. They think that gives them the ability to do whatever they want. I do agree with the argument that disclaimers cannot fix the problem if you find that land surveying has occurred. But I'm happy to ask any or to answer any questions you have about this. I know it's a lot of information, but I did feel like it was relevant, the information I gave you. And I also will state, if you feel like you don't have everything you need, we always have the option of further investigation and expert review if you feel like you need a surveyor that can look into this without anonymity. I can only do so much in describing something to you anonymously.
Sure. And I agree that it's a very comprehensive report here, a lot of moving parts. It's awful easy to get lost in the forest there and not see it, but I am familiar with those cases that were cited and have followed those for a number of years and looked this over. I'm glad you read our definition of surveying because that saves me from quoting it out, which would have been more time, but that's part of it. And again, since Tommy just got here, I don't want to force something that is this big onto him this quick. If he would prefer to defer it to another meeting or ask for more information and talk about it at the next meeting, I'd be okay with that. But I'll kind of quickly simplify it in my mind now that I've studied a bit and looked over it, is that, and I didn't, in all this, at no time did I see any reference to the fact that they had a certified or even a non-certified photogrammetrist working on the staff. It just says that they were doing photogrammetry. And so I'm going to take that at the word right there, is that they neither have a professional nor a certified technician involved in their operation.
Right. I'm just making an assumption here, but I would think if you had one, you would list them.
If you had one,
Especially
you
in
would
a-
list one. I would agree, because that's rather than disclaim that you don't need one, which is mostly what they've done right here. This actually goes back to our two gas lines cases, as we're saying that, I can turn out something that's looks like a survey. As long as I say it's not a survey, it's not a survey. But
Right.
disclaimers don't do anything as far as I'm concerned. If it looks like a survey and smells like a survey, it's a survey. And if you didn't sign it, then if your license didn't sign it, then you just violated the standards of practice. If you didn't stamp it because you don't have a license, then you're practicing without a license. And we'll, on that. And they keep talking about that they would get formal collaboration with a licensed surveyor when necessary or when requested, or that when they determine they need one, that they will work with one. We're starting to step into that same argument about what does it take to be in responsible charge of the survey. And it's not bringing somebody in. In Tennessee, we don't have anything that allows a consultant relationship. You're either in responsible charge and part of the company through some process, or you're not. Other states do have that ability, that they can bring you as a consultant to work on it. I do not think Tennessee has that. They changing the name from topographic surveys to drone surveys is totally ineffective. Doesn't do anything. A topo is a topo, and to me, topography very clearly falls under the practice of surveying. And if they're offering that service, that is the next part of that statute, is the practice of surveying is offering that service. They're offering that service. They are practicing surveying without a license.
That is what I gathered from this.
And to me, that's the bottom line of the whole thing here. I don't know where we go from there, but they have not. I would be interested in seeing their product, but again, that's really not necessary in my mind, because all these cases are dancing around on both the conduct as well as the product.
Right.
So if they're doing the conduct, what the product looks like doesn't really matter, and vice versa. So to me, it's clear that they are conducting surveys. I don't need to see the product to verify that they are putting surveys out, in my mind. And I'll shorten it to right there based on all that. I appreciate you taking time to read it. That kind of clarified and jailed everything I had in my mind onto it. I can't get past the fact that these guys are practicing and advertising to sell land surveying without a license.
Right, and I feel like their argument is just, well, we're not certifying it. And to me, that's even a bigger problem.
That's the same thing.
You're not taking
where you just come out,
responsibility
it's
for
a
your
survey,
product.
but we're not. We're going to say it's not a survey, so it's not a survey.
Right.
They don't have that right. No one has that right to do it. If it's a survey, it's a survey. I'd feel a little better. And again, the definition of professional is that you are practicing at a higher level. The public has the right to expect more out of you, and you get to be held liable for the effects of your professional opinions. And it's the same. And the definition for the certification for a photogrammetrist is about the same, except that they don't have the liability, but they still are to be expected to have certain skills, operate at a higher level. And so, but I don't see that these guys have either one of those things going for them. They're just practicing surveying without a license. And like I say, Tommy, if you want to kick this down to the next meeting, and I'm fine with that.
I'm leaning towards that. I do have a question, though. How do photogrammetrists currently fit under our law?
Under Tennessee law, they are required to utilize and hire a licensed surveyor to do the ground control and certify the control that they use for their product.
Okay.
And I do believe Tennessee has a certificate program for photogrammetrists that is required to actually be offering yourself as a photogrammetrist.
Okay.
Other states like North Carolina actually have photogrammetrists under the surveying law too.
But the actual product doesn't have to be certified by a surveyor.
No, it will be a note of who they got the certification from for the ground control.
Okay, so is determining those contours not surveying without a license?
Again, that is a point that I was worried about onto it. But, again, I think the difference is the fact that the photogrammetrists do require certification,
Right.
not licensure. So there is a process to protect the public there.
Sure.
And again, technology has kind of changed. The photogrammetrists weren't really talking about LiDAR at that time.
Right.
This was actually doing stereos, and
Sure.
you're familiar with that.
Oh, yes.
Which is a very specific skill step that most surveyors don't pursue anyway. On
Right.
that. So I can think that, but to be producing topography using ground shots, which is what we do, whether we're using a rod or LiDAR,
Right.
is very definitely under the surveying description.
Oh, sure. I don't disagree with that at all.
Yeah.
Okay.
Yeah, we're driving a stake in the ground here, either way we go for sure. So
Right.
don't do it lightly.
Sure, yeah, oh, no.
Yeah, I wrestle with it a little bit, just in the sense that I try to put myself, being the public member, I try to think, as an individual, would I, like for instance, I think this came up at the in New Orleans, but someone was talking about the use of a drone to measure dirt removal, maybe at a construction site, and
Well, I could help differentiate on that
Okay.
somewhere, because,
Yeah, I loved it.
Well, the law does very definitely say that surveying does include determining volumes, but then you also have to put in, are you selling that service?
Okay.
Which is the practice surveying. On construction sites where the contractor is merely trying to keep up with his own volume count, so that's how he's going to charge how much dirt he moved, he may be using the drone and the software that does that without a license, because he's not selling that
Okay.
service to anybody, he's doing it for himself. That and the fact that construction stakeout is a service that's not covered under Tennessee surveying law. They can do, stakeout can be done without it being a licensed surveyor. Other states do require that.
I feel
Sure.
comfortable. I feel comfortable with that because I would maybe like to use it. I don't want to sell the service, but for my own sake, for my own information.
For years, contractors, one rough way to get a volume is to count the number of truckloads.
Yeah.
So, we're not going to demand, no, you're surveying without a license if you count the dump trucks.
Yeah.
That's obviously ridiculous, but.
Yep.
Does that help?
Yeah, it helps
Okay.
a lot. That actually clears it up.
This issue here is not something new. This has been brewing for several years
Yeah.
now, and it all gets back to the topography stuff. Surveyors traditionally provide it because you have to be sort of an expert measurer to get that data, and surveyors are always expert measurer. And now the technology is allowing people that aren't surveyors to obtain this information, but the problem is how does it get regulated?
Yep.
Well,
And it does fit under our licensure, like you said.
Yeah, and we were, the definition, if I was around when our first stuff got written and the people who wrote it, the definition of land surveying was something that was not defined by surveyors. It was defined by the engineers and surveyors working together to decide what was surveying and what was engineering.
Right.
So in a sense, we didn't have the last word in defining what surveying
Right.
is. But now that it's been defined for us, that's what it is, and in my mind.
Right. I'd agree. So what do we need to do about this?
Well, I say I'm kind of deferring to you because this is a lot. This is a big thing, and this really is. We're pounding a stake in the ground, saying this is the boundary, guys. And if
really
you want time to think about it,
think we need time to
I don't
think
have
about
any
it.
problem, but I have thought about it a lot. I'm ready. To me, this is practicing surveying without a license.
I would really like Justin's input on this. Obviously, he's not here today.
Which is a legitimate, the fact that we can't get him on, that's a legitimate concern. To be doing it
Like you
without
said,
Justin.
this is an important decision.
So if we want to defer it, would the board like any more information from me? Would you like me to have an expert land surveyor review this without, with the benefit of being able to look at the website and look at everything and give me their expert opinion? Or do you just want to defer it for time to think about it?
For me, I don't require any additional information on
Okay.
this. I mean, the websites are, and the other problem is I'd be more attentive to give them a break on the website because those things are like viruses. You can't stamp them out, change them once they get out there. They just kind of keep heading around. But, I mean, the fact that you've made it very clear that all they've done is changed the name and taken survey out of the name. They're still doing drone surveys. They're just not calling them surveys. Switching that they do precise topographic maps doesn't make me any happier,
right.
though. So
They've made some disclaimers, but
Yeah,
like you said, they've not changed what they're offering.
Yeah.
They've not changed what they're doing. They've not even really made any argument.
Well, for me, I don't have any, I don't need any additional information.
Okay.
It's valid that it would be good for Justin to, because this is important. This is pounding a stake, and we want to be sure that we are together on this. And with Justin not being able to call in, that is a legitimate concern right there. But again, if you all have a request for additional information,
I mean, they are, your argument, which I tend to sort of agree with, is what they're admitting to violates the law. So
Yeah, I
they're
think
not- they're not
they don't
denying-
understand that.
What's that?
Clearly. They clearly don't understand the difference,
Right.
I think. They don't understand the
Right.
definition as they should of land surveying. It looks to be like a family business that has not been around very long. They don't have a lot of employees, so just giving you a little background on.
I would like to defer this till the next meeting when we can get Justin also in on this and have a full attendance.
do you want to request any additional information?
I don't know that I need any more information on this.
Kevin?
I would agree. I don't know that any additional information is needed, but I do think that this is going to keep coming. It's only going to come more and more as measuring techniques become. And as Tommy said, it's the device can do a lot of it now. As an engineer, the thing is, experts know when the information is bad. That's where the expert comes in. I mean, a lot of things can give you bad information, and if you're not educated in that subject matter, you could accept that as fact, as good data, and it may not be. So that's where it is important that an expert look at things. I mean, sure, I could go fly a drone, and I couldn't tell you if it was good or bad data. These guys could, but so it's important that an expert is at the end of that line.
Like you say, sometimes the expertise is knowing what you don't know.
Right.
So I guess, no, Erica, we don't require any additional
Okay.
information, but we would like to defer it to the meeting when we have the full board.
Does that require a motion?
Does that require a motion?
Yes, you would need a motion. Sorry, somebody.
Here, I'll try.
Sorry.
You would need a motion to defer until then, and just, when you make that motion, just for Justin's sake, he's probably listening to it now, but if he's not, just to summarize, is it the board's position that this, so far, the consensus is that this is unlicensed activity? Is that your feeling? Gary, you've said it, but is that your feeling as well?
Yes.
Yes, I tend to agree with that.
Tend to agree.
Because I just want to summarize it or I know legal will do that, but just for
Okay,
when he
so
comes
you'd like
back.
that to be in the motion as well?
But you don't have to. No, just deferring is fine. Yeah.
Okay, then I'll entertain a motion to defer this matter to the next meeting.
I make that motion.
I second the motion.
All in favor, say.
Aye.
Okay.
That concludes this legal report. Do we want to talk about, will we put this verbatim on the next legal report? I mean, of course, I don't have to read it again, but that way it's public again
Yeah,
in the
just to
same form?
represent, yeah.
Okay,
Can we put
perfect.
the actual Tennessee law in the,
Yes, I will fix that.
okay.
Well, I will probably state this is what complainant states and here is what
Yeah.
the code states.
I appreciated that, but I had that.
I apologize for that.
Okay.
Quick thing I wanted to add, as far as some legal updates, we will have a rulemaking hearing. You kind of touched on it earlier about some of those rules, but that is set for November at the next meeting. So looks like we'll have some more discussion, and then we'll have be a little lengthier because we'll have that rulemaking hearing. So just wanted to let you all know that.
Okay. I guess we can move on to new business. Is that
Yes, sir. Your PDH is just to remind you,
Oh.
if you want to do that, you've got 2 hours worth if you want to do that, but
well, can we wait until after we hear from the public in any comment? Because we're not quite done. So. And we'll hit that at the end of the public comment then. And so, anyone, you want to take it from there?
yes, sir. If we're ready for unless there's new business, we're ready for public comments then? Is that what I'm hearing?
Yes.
Okay, sounds good. All right. You don't have anyone online? Yeah, we were kind of running through some trouble there. All right. Let's read what we got here at the podium. Nayland Franks then?
Good morning. I'm an applicant. My license number is 3675 LSIT, not a licensee, but that's what I'm here to talk about. I've talked to Mr. Clark about it a couple times on the phone, but I just kind of wanted to lay out my situation, and maybe others have had similar situations. I'm not sure. So I have passed the FS, the PS, the TS. I have a college degree unrelated in surveying. It's in business management from MTSU. I have 9 years and 2 months experience surveying, and in December I will have my 18 hours of surveying related courses done. My boss, the licensee that I work for, Kenneth Carroll, his number's 1335. He is 80 years old. I've had to talk him out of retirement once this year already, and he's on the verge of it again. And the counties that we mainly service, his office is in Hohenwald, so that's Lewis County. We work Lewis County, Lawrence, Wayne, Giles, Hickman, Murray too. Murray has a couple other surveyors, but most of these counties have one, if not no, surveyors in the counties. Lewis County just last December gained another one, a guy that used to work with me under Kenneth. But there was an older gentleman that had a stroke and had to retire. So Lewis County will be, when Kenneth retires, Lewis County will be back to having one surveyor. Like I said, Lawrence, Giles, all these have one, if not no, surveyors in the counties. I just want, in December, I'll have the test passed, the classes under my belt, and I will be 6 months short of the 10-year requirement for Pathway 5. I really just wanted to talk about if there was any way that there's anything that can be done. I've heard in the past, Mr. Clark told me on the phone that he has not heard of this since he's been on the board. I've heard in the past, and this is just hearing through the grapevine of working in the industry, people telling me, hearing stuff at TAPS, this is all hearsay. But people have told me before that the board has been petitioned about people getting licensed like on a waiver or something of that nature. But again, y'all were talking earlier about how we're trying to recruit people into the profession, and I'm able to do the job. I'm not asking for special treatment. I want, for the good of the public in the counties that I serve, we already can't keep up with demand. And when Kenneth retires, and if I'm not licensed yet, there's going to be an issue there where it's going to fall even further behind. These counties are high. They're fast growing. There's lots of jobs coming into Lawrence County, especially, and Murray. But there's there's a lot going on down there, and the surveyors available cannot keep up with demand. And I just wanted to talk about this issue and see if this, and I know that there were no applicant stuff on the agenda today. I don't even expect you to say anything back to me today. I just wanted to come see you in person and meet you all in person, come to a board meeting. I've learned a lot since I've been here. The complaints were interesting, but
One might say even entertaining.
yeah, it kind of scares me a little bit. Some of it does, but yeah, I just wanted to come introduce myself and kind of present my case that if there's anything I could do to, with 9 years, 6 months experience, once I have because in December I'll have right now I think I have 15 hours of surveying related classes. Like I said, my degree is in business, but in December I'll have 9 years, 6 months surveying experience, and I'd like to for y'all to maybe consider if there's anything that I could get licensed 6 months early even. Just the counties down there cannot keep up with the demand, and I understand that the requirements of the board are necessary. Not anybody, like we were talking earlier about all these other states that are trying to do away with boards. I think that is ridiculous, because if you go survey for 6 months and you know that a lot of the people you survey for shouldn't be surveyed, that they have no idea, and it's not their fault, but they shouldn't be surveying. And if the boards go away, then people like this will be surveying, because surveying seems to be everybody I talk to, it's amazing. Everybody I've talked to has either surveyed at some point in their life or they are trying to get their son into surveying.
You've noticed that, haven't you?
That happens a ton. I mean, somebody says, I surveyed in the 70s, I surveyed in the 60s. My dad surveyed, and he is not a professional surveyor. He surveyed in high school. So it's all over the place.
And they feel qualified to advise us while we're out there, too.
Yeah. Mm-hmm. The best are when they say, I don't know where the corner is, and then you find the corner, and they say, well, that's not right. It's like,
I know it's not there.
Yeah.
I don't know where it's at.
I don't know where it's at, but I knew it wasn't
That
there.
seems to happen a few times.
That's
too.
not where Granddaddy said it was.
Yeah.
Your
Yeah.
granddaddy was a liar, right?
Yeah. That's not where my grandpa told me 50 years ago where it was. And it's on a creek bank. But
Well, we do appreciate you coming in. I mean, it's nice to actually talk to an applicant. We don't always get to do that, and it helps in the situation. Are those counties in your neighborhood, or?
They're
They're-
sort of southwestern,
they're
middle Tennessee.
southern middle, yes.
Okay,
I mean, I've worked in all of them. I'm familiar with
sure.
Kenneth Carroll and Eddie Cleghorn. And
Yeah. And Eddie's another one that could retire anytime.
I don't know that he's on particularly good health, is he?
I know his wife died unexpectedly last year.
I did not know that.
And I heard at the time I heard that he could retire at any time. Now I heard that through an engineering firm I was doing some work for. So I don't know. I've only ever met Eddie once or twice.
David Parsons, you familiar with?
Yeah.
Familiar with David Parsons?
I know David. I've met David Parsons. Yeah, he used to work for Kenneth at one time.
I worked for him for one summer,
Yeah.
nearly 30 years ago.
And he's one that he does all his work is in Wayne and Lawrence County.
Right.
And then, I mean, him and Eddie and us are the only ones that really do work in Lawrence County.
Man.
So,
I certainly sympathize with your position here. I'm just not sure that we have any leeway to
Well, it's-
bypass the rules.
You know, again, I'm glad you came in and talked. I'm glad you're not asking for a decision right now. You know, some of this I'm going to have to, throw to legal, and maybe they need time to consider if there is any wiggle room we have. We do obviously have to be very careful on that, of not opening a door for it. And there is a clause in there about we have some power to adjudicate, but I'm not sure where we draw the line on that. But I don't mind looking into it in more detail for you on that. One of the things I told you was because you were everybody was telling you what the requirements are.
Oh,
Or that may be someone else, where I said, just quit listening to them and go
Yeah.
onto the website and look it up. And because there's a lot of misinformation going around too. y'all have any thoughts here
We were
now?
sidebarring for a second, and the legal will pitch in and keep me, keep me from speaking legal heresy or anything. But
Yeah, I mean, it's odd that we had this one where they were bending the rules to look after a cousin who was going to take his test. And,
Yeah.
that's the problem with allowing something to happen with the idea they're going to fix it. Now the kid apparently can't pass the test.
Yeah.
So,
one of the things that I've done too when I go do an outreach with TAPS or others, I kind of do a quick little civics lesson. Not that anyone necessarily needs it, but just to put it in front of folks' mind so they understand what scope or what authority the board does have. And it's limited. The board's authority, it would be limited to what's not, what's allowed through statute. And so when you have the 5 pathways are articulated, and pathway number 5 is 10 years. Now, I would say that if there were special circumstances, and then you could just send that to me in writing, and then legal could take a look at it and then sort of mine down. But just if we're talking, in the larger sense, then there would be no discretion outside of what's specifically allowed in statute itself. And so, where the board has discretion is where that's intimated. Where there's where that's specifically articulated, where we need your subject matter expertise. Where we can't necessarily connect the dots, and we have to yield to the board to sort of define that for us. And they usually do that in rule, and so that's helpful. But unless the statute was to change, there's the 5 pathways are the only pathways available to us. And probably some of the folks, I've heard folks talk about hardship. Usually what they're discussing in those times are CE, if they're over 65, and then they can take they don't have to take there's 2 hours that they have to take. But, that's the extent of hardship, but there's not any variance or leeway or discretion afforded to the board to deal with what is the 3-legged stool: education, experience, and exam. You've got the exams, which is great.
Yes, sir.
You've got the almost have the education, working on that, and so then that leaves us with the exam or with the experience level.
Right.
And so
and the hardship is what I was wondering because sometimes that comes into play from a statute that's not specifically surveying onto
Right.
it. I mean, similar to where, apparently it was by reason of hardship that we have to accept minimum standards training from another state instead of from our own.
yeah, and if there's any sort of any sort of variance
rules we
outside
want
of our
changed, too.
anything outside of our statute, again, that's why legal and I were discussing that.
That's where, I got to kick this back to you guys
Yeah.
on it. 'Cause
Then
it
you would
goes a
just send
little
it to
further.
us to look at.
Yeah, I would just add, we definitely appreciate the comment. I don't know if it's a pending application or anything like that. Obviously, that's not in front of the board today. So if you do have any requests, I would suggest you shoot it to Glenn over here, Executive Director. We can certainly, look into it. I would kind of emphasize kind of what Glenn said. There's not wiggle room on any of the statutes, but, we can definitely take a look at it to make sure.
That would be the proper process then, anyway. At least we've identified that. So
Okay.
you'll make your request for the waiver that you're looking for, the relief that you're looking for, and send it to Glenn. They will look into it, and we can get you an official ruling on it one way or the other.
Gotcha. Thank you. Appreciate it.
Thank you.
All right. Chair, did you have anything else?
Anyone else has any comments today? Good. Got observers. All right. All right, then I guess we need the motion to how many credit hours this will take. We've been here just over 2 hours. Move that we take 2 hours of credit.
So moved.
Second.
All in favor, say aye.
Aye.
Thank you. Then, any other business that we need to look at here? We got this under control. In that case, I will entertain a motion to adjourn.
So moved.
Second.
We stand adjourned.
All right, thank you.
Thank you all for